Hello, I'm Michele Shuster.
And I'm Chad Blackham.
And welcome to another edition of Compliance Talk with Chad and Michele. Really excited to be with you here today because we have so many interesting things and kind of diverse things to talk about today. In case you have not noticed, the FCC has been very busy over the last month. And there are two specific notices of proposed rulemaking that are going to be addressed in the next FCC meeting, which is scheduled for March 26th. One of them has to do with foreign call centers or foreign originated calls. This one could be a significant issue, especially for larger companies that are offshoring or outsourcing to foreign lands their call center operations. And so the FCC has kind of generally said that they are targeting offshore call centers and that they believe that they provide poor customer service, increased fraud, privacy risks, and foreign originated robocalls. And so I think that's quite a broad, sweeping categorization of foreign call centers. Boy, in the years that I've been practicing law in this area, I have been to so many different countries and audited foreign call centers. A lot of them have really done a great job with compliance implementation, with security of the records that they obtain, and just really providing great customer service. So I think this broad, sweeping categorization is somewhat problematic, and I'm very much hoping that anybody out there that is utilizing foreign call centers that is doing a great job out there, that you think about filing comments with the FCC, and we're certainly happy to help with those types of things. But so, I mean, these are very significant regulations that would go into effect if you are using foreign call centers. The first potential is that it would limit, this new rule would limit the percentage of calls that could be foreign-based calls for your foreign-based call centers as compared to the ones that originated in U.S. soil. So coming up with some type of arbitrary allocation of those percentages as to what they would think would be appropriate. Also, to allow any caller to request to be transferred to a U.S.-based call center. And along with that, the foreign-based call center would have to disclose the fact that they are foreign-based, which could prompt that request to be transferred to a U.S. Call center. There's a proposal that bonding would be required for the foreign-based call centers, and there's also tariff implications that if goods or services are being sold that are from countries that have tariffs, that those tariffs would also be applied to those products or services sold via the telephone call. So lots of stuff going on here, and this is on the tail of the FCC also putting out for comment whether foreign originated calls should be labeled as foreign originated in the caller ID of those calls that are being originated. So again, I really just want to make sure that anybody who's using a foreign call center understand what the implications of this could be from a financial perspective, definitely for additional regulation, also additional reporting. I mean, this is complex stuff that the FCC would be implementing. So let us know if you need any help with that. All right, the next one, and this one is really, I don't think, receiving as much attention as it should be. The FCC has also released a request for comments around the use of number rotation. And of course, what they mean by that is that when a telephone number is assigned from the North American numbering plan administrators for phone numbers, that is often not the entity. Usually it's a carrier who's getting that number assigned to them because they have access to those numbering resources. But then it's resold to VoIP providers and others that are making the phone calls or potentially enabling others to make the phone call. And so the FCC has, how have they put this? They believe that while bad actors can initiate an illegal robocall in a variety of ways, it starts with a telephone number. How's that for opening
That's strong.
comments? So they are looking at implementing some additional requirements, and they've put out a number of different potential options that could be that requiring anybody who has access to to numbers, either through your current carrier or through even a downstream from there would have to register to get access to those telephone numbers. So basically increasing the registration regimen for that. Also requiring that if there is any reselling, if they don't go further with this registration requirement, that there would somehow have to be a disclosure that a reseller is actually using that telephone number. And so that could be through expansions in the potentially robocall mitigation database or other restructuring. So, I think that what the FCC is saying with this is this rotation of numbers, which is a very common practice with telemarketers and with other companies, because there is the ability to have calls blocked and labeled out there by the carriers. And with that, it's really required a strategy for making sure that the numbers don't get wrongfully blocked or labeled. And so that's led to a lot of different type of regimes, I guess I will call it, with number rotation being one of those. So again, if this is something that affects you, and I assume it affects a lot of the people that are listening to this today, reach out, let us know how we can help you in getting comments to the FCC. It's definitely something you will want to weigh in on.
Absolutely. And, Michele, you talked a lot about foreign call centers and some of the foreign priorities that the FTC and FCC are going to be looking at in the coming years. I'm going to shift a little bit over to the domestic front and talk about some really, really interesting case law developments that we've seen. A lot of you may have seen this one, but in particular, we had a very, very notable case come out of the Fifth Circuit called Bradford v. Sovereign Pest Control of Texas. And if you haven't heard of this one, this is why it's important. So the Fifth Circuit recently held that PWC, prior express written consent, is actually not required to send an ATDS or message through an ATDS or a pre-recorded message. Now, for those of you who are on top of your compliance obligations, who regularly review your requirements and what you must follow under the TCPA, the TSR, and all these great telemarketing laws, a light bulb might have just gone off in your head. You may be like, well, hold on a minute. That's in direct contravention to pretty much everything I've heard over the last decade plus. Mm-hmm. And you would be completely right. That's why this is partially such a notable ruling, and in fact follows a couple of other similar rulings we've seen in neighboring jurisdictions. So the main point I want to get across here is that this is part of a continuing and evolving body of case law stretching back a few years to the abandonment of Chevron deference. This was basically a very large administrative ruling that held that courts are not necessarily entitled to give different deference to agency interpretations. We saw an expansion of this in the TCPA context, specifically with the subsequent case, McLaughlin v. Chiropractic Associates, which basically held that the district court in that case had the authority to vacate a ruling under the Hobbs Act. This is all to say that FCC orders, FCC interpretations are a little bit up in the air right now. And that's exactly what happened here. So in Bradford, we had a very, very typical situation, I would say. A plaintiff entered into an agreement, was receiving auto-dialed calls, pre-recorded calls, later complained that he didn't want them and that they were being sent impermissibly without his prior express written consent. Now, what the court did here is kind of remarkable. They looked to the strict text of the TCPA, and interestingly enough, for all the listeners out there, the text only actually mentions prior express consent without the written portion. The written portion comes from a subsequent 2012 order. And what the court did is what they said, well, we're going to look to the statute, and because we aren't required to provide this deference, this is where our inquiry begins and ends. And because it doesn't say anything about written consent, prior express consent is sufficient to send messages with an ATDS or via pre-recorded message under the TCPA. Now, for all of you who are getting really, really excited and thinking, well, gosh, I can do whatever I want in Texas now, I would caution you, not quite. This ruling is only in the Fifth Circuit in a few jurisdictions, but importantly, the TSR, the telemarketing sales rule, still has a written requirement pursuant to its regulations. So we're not completely out of the woods yet, but this case does reflect a very, very interesting and evolving body of case law, abandoning prior FCC interpretations, including a couple that we might talk a little more next time.
I was just going to say, we should do a whole session on just what's in play now with
I would love to. And to preview it, yeah. A lot of courts, or some at least, have started to take the position that a text message may not necessarily be a call under the TCPA, which, this is a big upturning. That would be a massive one.
That would be massive. And I think we're up to like 12 cases now. And I think 4 or 5 of those are even out of Ohio. So it's a very interesting development. The other one that's kind of interesting in this area is the notion of prior express consent to receive, or I should say to call somebody's on the do not call list. And this is a definition that the FCC has provided their guidance on. It's not defined by statute. And right now, it's if the consumer has provided their telephone number as a means of being contacted and doesn't give instructions not to contact them using that telephone number, then you could for purposes of do not call. Again, that's an FCC interpretation. So when we talk about things that are in play, there's a lot of interesting things that could happen in the next year or so.
Right, because it's an FCC interpretation, courts are not necessarily bound by it in giving it deference anymore. That's a great point, because the do not call list is such a staple of this industry, of the telemarketing space. It's almost taken for granted in a lot of respects.
Yeah, for sure.
But similarly, talking about communications with customers, advertisements, I'm going to shift over slightly to the realm of email instead of just calling and texting. Now, a lot of you are likely aware that email messages are not necessarily subject to the same stringent regulations that calls and texts are. The most well-known law is the federal CAN-SPAM law, which regulates federal email messages to some extent, prevents spam, very, very limited protections. A couple of other states, however, including Washington, which is probably the most prolific, have implemented these new state laws providing private rights of actions to consumers and statutory fines in the case of certain email messages. In particular, with Washington, their law prohibits deceptive or abusive subject line headers. Right? If you have a subject line in your email, it has to be truthful. It cannot misrepresent anything whatsoever or be deceptive in any way. What's really interesting about Washington's law is it provided statutory penalties of $500 per pop. And we also saw a massive, massive influx of plaintiffs' attorneys and plaintiffs trying to bring claims under this law. We see this very, very often anytime a new law is implemented, particularly those with private rights of action. And this Washington email law was no different. What's really notable, however, is that we're seeing a move by the Washington legislature to actually reduce the statutory penalty for a violation of this law from $500 all the way down to $100. Now, it's very, very rare that you see the state and regulators reduce the penalties, so it's notable for that reason alone. But what I also think is very interesting is that the federal CAN-SPAM law, it expressly contains a preemption provision in it, meaning it would supersede contradictory state laws. Notwithstanding this provision, notwithstanding the arguments of quite a few parties, many courts have upheld the validity of the Washington and other email laws in this context. So it doesn't look like they're going away anytime soon. It looks like it's something that all of you are going to continue to have to contend with when sending email messages, making sure everything is above board and everything is truthful. But on the bright side, it looks like the potential liability, at least for the time being, has been lessened a little bit.
Yeah. And as well as Washington, California, Nevada has had a very active plaintiffs bar for similar laws that those states have. And the other interesting thing is with CAN-SPAM, it preempted state laws that kind of directed the technical implementations of email messages and those types of things. But what it didn't preempt was state UDAP laws, which are unfair, deceptive acts and practices law that broadly prohibit any unfair or deceptive claims that aren't capable of substantiation at the time that they're made. So remember that you still have to look through those emails, make sure you can substantiate every claim made, including the subject line, including who it's from, and not using basically an identity that wouldn't identify that the seller is who the seller is. So lots of interesting stuff here. It's going to be continuing to evolve, but don't forget about your emails as you're focusing so much on telemarketing and texting compliance.